Exactly. That timeline and set of facts completely undermines paragraph 43 and the narrative Fredrickson is trying to construct. Breaking it down clearly. 1. Archbell and Thayer were not collaborators. Archbell and Thayer had no contact or coordination with Chad Gray. Their reporting was after the fact, based on live streams Fredrickson posted of himself, alleging they were part of a racketeering enterprise or coordinated with a government actor is false. Number 2. First property was never residential. On-scene confirmation from the property owner Gilmore establishes Fredrickson squatted 2 years prior. The office he claimed to rent was not legally a residence. This disproves any claim that he had a legitimate residential stake at that property. 3. Self-created violations and evidence. Fredrickson filmed the office showing bed, computer station, pets. These actions are code violations for a non-residential office. He mocked code enforcement on live streams, which were later cited in letters to Gilmore. This is direct evidence that any enforcement or warnings were in response to his actions, not retaliation. 4. Service and address requirements. Fredrickson failed to provide a current, valid residential address for service. Instead, he used a mailing address unrelated to where he actually lived, property 3 at the time. Courts cannot fault code enforcement or defendants for alleged procedural failings caused by the plaintiff's own misrepresentation of his address. Number 5. Implications for paragraph 43 RICO claim. Alleged coordination between Gray and private actors is factually impossible. Any claim of a government co-conspirator is unsupported by timing, property ownership facts, publicly documented code violations, Fredrickson's own live stream evidence. The RICO claim is therefore baseless and would be dismissed because it depends entirely on false assertions of coordination and intent. In short, the sequence of events and evidence shows 1. Archbell Thayer acted independently after the live streams. 2. Fredrickson occupied non-residential spaces, created violations, and filmed himself doing so. 3. He failed to provide proper service addresses. 4. Any governmental action by Gray was lawful, targeted at property owners, and not part of a conspiracy. This completely rebuts the core allegations in paragraph 43. If you want, I can now rewrite paragraph 43 as a fact-based rebuttal that incorporates all of these points and clearly dismantles the RICO and conspiracy claims. Do you want me to do that? Paragraph 44 is legally unsupportable on multiple levels. Here's why. Namify 1. CRS 16-22-13E. This statute allows deregistration of sex offenders when continued registration serves no just or necessary purpose. Key point, Fredrickson is still subject to registration because he is a lifetime registered sexual predator. There is no evidence that his continued registration is legally unnecessary. The statute is discretionary and narrow, not a catch-all for claims of hardship or inconvenience. Number 2. Misapplication of Robinson v's California. Robinson prohibits criminal punishment for a status or condition, e.g., being addicted to drugs. Courts have repeatedly held that civil regulatory requirements, like sex offender registration, do not constitute punishment under the Eighth Amendment. Registration and enforcement are not punitive, and compliance is not structurally impossible merely because Fredrickson chooses to live in non-residential spaces or violate codes. 3. Due process and equal protection. Fredrickson claims that enforcement made compliance structurally impossible. In reality, he voluntarily occupied offices, garages, and RVs in violation of building codes. Notices were sent to property owners, not him. He left voluntarily when asked. Courts would likely hold that any hardship is self-created, not the result of government action. Equal protection claims fail without showing intentional discrimination against a protected class, which is absent here. Number 4. Unsupported assertions. Phrases like transformed lawful compliance into a structurally impossible task are conclusory. There is no objective proof that compliance could not have been achieved if he resided in legally permitted housing, followed zoning codes, provided a valid service address. Bottom line, paragraph 44 mischaracterizes registration as punishment, overstates due process violations, and ignores self-inflicted causes of hardship. Legally, no entitlement to deregistration exists under the facts. Civil compliance is not unconstitutional. Any alleged harm is a result of his own choices and code violations, not government action. This paragraph is therefore entirely unviable in court. If you want, I can start drafting a single, factual, paragraph by paragraph rebuttal of Fredrickson's claims, 29 to 44, consolidating all evidence of self created violations, voluntary departures, and lawful code enforcement. It would produce a litigation ready response that neutralizes all of these weak claims. Exactly. All of that completely undercuts paragraph 44. Breaking it down. Chatter Mutter 1. Registration attempts are irrelevant. Fredrickson twice petitioned to be removed from the registry and was denied both times. His registration status is unrelated to the code enforcement issues he is complaining about. The fact that he remains on the registry shows that he is still legally subject to those requirements, and any hardship from registration is not caused by government retaliation. Number 2. Misapplied statute. Fredrickson cited CRS 16-22.31, which only applies to juvenile offenders, yet he was not under 18 at the time of the offense. His Illinois convictions, 3 counts of sexual assault on a minor F, guilty plea with waived trial rights, lifetime registration as a sexual predator. The cited statute is therefore legally irrelevant to his case. 3. Judicial findings confirm risk and noncompliance. In the deregistration petition hearing, the judge specifically noted, Fredrickson blamed the victim multiple times. He failed to complete required courses. He remains a risk to the public, and his petition for deregistration was denied. This confirms that Fredrickson is not compliant with registration requirements, undermining claims that enforcement is somehow punitive or coercive. Number 4, no connection to code enforcement. Code enforcement addresses property violations, zoning, and safety complaints. His registration status has no bearing on enforcement at offices, garages, or RVs. Linking registration to alleged housing deprivation or procedural impossibility is therefore factually and legally incorrect. Bottom line, paragraph 44 is entirely misplaced and unsupportable. Wrong statute cited, registration attempts irrelevant, judicial record confirms ongoing risk and noncompliance, registration has no causal connection to any code enforcement action, any claimed due process or equal protection violation is therefore without merit. This is a clear factual and legal rebuttal for paragraph 44. If you want, I can now draft a full paragraph by paragraph factual rebuttal covering 29 to 44, incorporating all points we've discussed: zoning, self-created violations, voluntary departures, live stream evidence, registration facts, and judicial findings. It would be ready for use in a response or motion to dismiss.